You've been charged with a domestic assault in Regina. The police released you on the condition that you have no contact with your partner. If you do have contact, you may face new charges, but you want to have contact. Your partner may also want to have contact with you. Unfortunately, because the police and the courts are now involved in the relationship, the decision to have contact is no longer up to the two of you alone. So what do you do? In Regina, there is a domestic violence court which deals with these types of charges. There is a 3-stage procedure for amending no contact conditions, and it generally takes 2 or 3 weeks from start to finish. The first step is for the court to order an assessment to determine what risk factors might be present in your relationship. The second step is for the prosecutor to review the assessment and decide whether they agree with removing or changing the conditions. Finally, if the Crown agrees to change the conditions, the changes are made in court. If the Crown does not agree to the changes, then it's up to you to convince a judge that the changes should be made. So let's take this one step at a time. First, the court-ordered assessment. This is a procedure unique to the Regina Domestic Violence Court and is not available in most other areas of Saskatchewan. You have to ask a judge in court, often on your first court date, to order a non-contact assessment. The judge will adjourn your matter for 2 to 3 weeks for the assessment to be prepared. During that time, someone from Family Services will obtain information about you and the alleged offense. They also interview your partner. The worker from Family Services is trying to assess how risky the relationship is. They identify specific risk factors and then rank those risk factors against an Ontario-based study. Based on your ranking, Family Services will recommend either that the conditions be removed or changed, or that they stay the same. At the second stage, a copy of the assessment is provided to you and to the Crown Prosecutor. It is then up to the Crown Prosecutor to decide whether they agree with making changes that are recommended or not. If the prosecutor agrees to change your conditions, and you're satisfied with those changes, then the change is made in court in front of a judge. However, if the prosecutor does not want the conditions changed, or you're not satisfied with the changes that they would agree to, then you have to convince the judge that your conditions should be changed. The fact that you and your partner want to have contact is not enough. The judge has to be satisfied that any changes will allow your partner to stay safe and allow your partner to testify against you if the matter proceeds to trial. As you'll note, this process involves at least 2 appearances in court and often involves negotiation with the prosecutor or even calling witnesses and making arguments in front of a judge. Your needs will be best met by a criminal defense lawyer who has experience with the prosecutor and the judge and who knows the court processes and the law. I'm Brian Smith. Thanks for watching.